Officer Dave, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Morning, Counsel.
Good morning.
Judge, how are you doing today?
Great. We're on the record, gentlemen. This is file 22-178-360, Briggs Realty PLLC versus Christopher Kelly. This is the date and time for a motion for summary disposition filed on behalf of the plaintiff under MCR 2.116 C10. Appearances, please.
Morning, Zachary Tree appearing on behalf of plaintiff P83966.
Good morning, Your Honor. Kyle Dupuy for Mr. Kelly, P72892.
Plaintiff's motion.
Judge, this is a relatively straightforward motion to recover or complaint to recover a commission. There was an exclusive right to sell agreement for the property that was entered into on June 22nd, 2021 through November 30th, 2021, which was duly signed by plaintiff and defendant. Defendant has, or I should say, a purchase agreement was entered into by defendant during that term. It was subsequently discovered that the defendant did not actually have ownership of the property. It was the ex-spouse who retained it in the divorce proceedings, which was not disclosed to plaintiff. Pursuant to the exclusive right to sell agreement, the seller represented and warranted to them, to plaintiff, I should say, that they are the exclusive holders of the interest to convey title to, and due to the breach, a commission is owed in the amount of just over $2,000.
Was the property sold?
It was not sold due to the title issues. However, pursuant to the agreement, as long as a buyer is provided, then commission is owed upon that. There is no requirement that the property be sold.
Let me hear from the defendant.
Well, Your Honor, in or about 1982, defendant Christopher Kelly's ex-wife, Andrea Kelly, purchased the real estate in question. In 1997, Christopher Kelly and Andrea Kelly got married. And then in 2003, Andrea Kelly deeded the property to defendant and herself as tenants of the entirety, and defendant's name was added to the mortgage. On September 1st, 2005, the parties divorced and the court awarded Andrea Kelly the premises and the judgment of divorce. As a condition of the judgment, Andrea Kelly was to get the house refinanced, removing Christopher Kelly's name from the mortgage. Ms. Kelly never got the premises refinanced and never removed Mr. Kelly's name from the mortgage. And then in 2019, she passed. Immediately thereafter, Mr. Kelly began paying the mortgage note since his name was on the mortgage. On June 23rd, 2021, defendant entered into a purchase agreement with CTD Holdings to purchase the premises in question. And since Andrea Kelly never complied with the divorce judgment requiring her to refinance the premises and remove defendant from the mortgage, and since defendant's name was still on the mortgage 16 years after the judgment of divorce, and since Andrea Kelly had passed away, and defendant had been paying the mortgage note for over 2 years, defendant believed that he was the owner of the property. Prior to signing the purchase agreement with CTD Holdings, defendant hired plaintiff to handle the legal work related to the closing. On June 18th, 2021.
Let's stop right there. Do you agree with that, Mr. Counsel for plaintiff? That prior to entering into the purchase agreement, your client was hired to do the legal work related to the closing? Do you agree with that or not?
He was hired to do that, but he was also hired to to sell the property.
Okay. Mr. Dupuy, would you continue, sir?
Sure. And 3 days prior to defendant signing the purchase agreement with CTD Holdings, Scott Briggs said in an email that the owner, quote,
Who's
appears to
Scott
be,
Briggs?
he's the principal of Briggs Realty.
Okay,
He
continue.
said, quote, owner appears to be Andrea Robin. Is that the current wife? Question mark, ex-wife, question mark. That was in an email to defendant. So he acknowledged that defendant did not own the property clear and free. And so thus plaintiff knew before signing the exclusive right to sell agreement with defendant, the defendant did not own the property and he should be barred from any attempts to extract commission from defendant for a sale that never happened. So defendant moves this court to enter summary disposition for defendant since plaintiff knew that defendant did not own the property prior to entering into the exclusive right to sell agreement and since the property was never sold.
Let me hear from plaintiff. Any rebuttal?
Well, first of all, defendant never submitted a motion for summary disposition, so I don't know how you.
I agree.
requesting a summary disposition. However, I would say that email doesn't state that. That doesn't state anything. That's just saying that he notes that the
Your principal says there's a problem with the title before the agreement is settled. That is signed. Isn't that what that email says?
It says that he acknowledged that it was owned by the ex-wife, and then further in the email, it says the ex-wife is deceased.
Okay.
So,
So correct me if I'm wrong, but my recollection of what I have been told so far is that prior to the signing of the purchase agreement, your principal was hired to do the legal work necessary to get things in order. My reading of the divorce decree said that if anybody had not done what they're supposed to do, that the other party could record the deed, record the divorce decree, and it would operate as the transfer of title. Did I read that correctly?
yes, Judge.
So then, given the fact that your guy was supposed to do the legal work before the entry into the offer to purchase, why didn't he simply record the deed? I mean the divorce decree. It would the lady's death certificate would of course be a member of public record, easily recorded, right? The property would have been conveyed by the filing of the divorce decree as was provided for in the divorce decree. So your client could have resolved all of his problems here that you're describing. And again, I note for the record, there's no affidavit of any purchaser that says, hi, I'm Johnny Smith. I was going to purchase it, but I had problems with the title. This is a C-10 motion. It's not there. It's just a statement by counsel. But your client was in a position to resolve the whole problems that he now complains of. And he failed to do so. Is that a fair description?
I don't know that he was given the opportunity to do so.
Tell me why not? A death certificate is public record. The divorce decree, public record. Again, I'm confused here. The divorce decree says wife gets property at issue. And if you guys don't comply with the terms of the divorce decree, you record it, the register of deeds, and that recording of our divorce decree will operate as a transfer of title. Your client did not, even though he recognized there was a problem with the title, did not even check to see whether or not the wife's death certificate had been recorded as to the property. Did he do that?
Not to my knowledge.
Okay. All right, I'm prepared to rule here. This is a C-10 motion. Court is required to be liberal in finding the issue, the existence of genuine issues of material fact. Given the fact that the plaintiff's principal was personally aware that there was at minimum a problem with the title prior to the time that the exclusive agreement was entered into. Given the fact that the problem with the title could have been easily cleared up by someone who had agreed to do that, that is plaintiff's principal, by simply doing two things: recording the death certificate of the lady, recording the divorce decree, both of which were public records. It's not like you had to get some specific secret information from somebody. Both of these are public records. Given the fact that there is no affidavit from anyone to say, had there not been these problems with the title, I would have bought it for this price in the time window provided for by either the original exclusive offer to purchase or its extension. Given the fact that the property was not sold, the court finds there to be genuine issues of material fact. The motion for summary disposition must therefore be denied. I will send you gentlemen out in order. Thank you both for coming in. We are off the record. We'll give you another pretrial date too. I guess I should do that now. How about I have you guys back on December 5? Does that work for everybody?
Would that also be at 10 a.m.?
Yes, sir.
Your Honor, excuse me, I'll be on vacation on the 5th of December.
Well, then that's obviously not a good day.
No.
Let's see. How about December 1, which is the previous Thursday?
Yeah, I'm sorry. I'll be gone from the 29th to the 5th, Your Honor. Sorry.
Well, then I'm gonna have you guys back. I need a calendar here. I don't see much time for us until then the 12th of December. Does that work for everybody?
That's fine for me, Judge.
Can we do, well, let's see, I have at 10:30. I guess at 10, we shouldn't take very long. 10 o'clock?
All right,
Okay.
December 12th at 10 o'clock. Plaintiff's motion for summary disposition is denied for the reasons set forth on the record. Thank you,
Thank you,
Joe.
Judge.
Let's
Thank
be
you, Judge.
safe out here.
Have a good day.
You too. December 12th.
music by Nuno Helmerson, the Grand Master Suite with Ajaz Vivo and Mark Guitar. And before that, the Scherzo from Heavy Line and Hits, the top innovation. With the Tanzanians in the orchestra of Alex Mills of the company. You're listening to Tempo, and this is the music. It's basic human nature.
Hello,
Hello,
what is your name?
Brittany Tyner Ward.
That's Ruth. All right, we'll get started in just a second.
Okay.
We are on the record calling file 22-189431, Universal Collections versus Brittany Tyner Ward. Date and time for pretrial. Your appearances, please.
Judge, may I please court? My name is Attorney Richard Russo. My bar number is 35222. I'm the attorney of record for the plaintiff. I'm also the attorney for plaintiff in this pretrial.
And your name, ma'am.
Brittany Tyner Ward.
All right, this is our second pretrial on this file. When we were last together on October the 10th, the court opened written discovery. What's been done in that regard?
Judge, I can tell you as the attorney for the plaintiff, but I have sent to defendant as my proof of service is dated October 13th, 2022. A copy of plaintiff's request for admissions, a copy of plaintiff's request for production of documents, and a copy of plaintiff's interrogatories from defendant. I do not have a copy of defendant's answer to this written discovery, but defendant, on the other hand, is still within her time under the Michigan court rules to file her written answers.
Okay. And Ms. Tyner Ward, are you going to do any written discovery?
Well, I'm not even sure what that is because last time when we was on the phone, I was trying to find a lawyer, but everyone said since the case was so long ago from the original case, which I never knew nothing about because when the landlord, Terry, filed it, he didn't spell my name right, and I was already moved out of his property when I guess everything supposed to had occurred. So I didn't get the chance to defend myself the first time, and that was 6 years ago. So I don't have no, text messages that me and him had conversations or anything. And I know the lady who did give me some legal advice from one of the little free aid services. They just told me that I need to write or text up my written answer, but I did and I sent it. The court told me, the young lady at the counter told me I had to send him a copy. I kept a copy and then they kept a copy down at 36th District. If that's not it, then I'm not actually sure what else he could be talking about.
He's saying he sent you documents after you filed what you described as your answer. Those documents are aimed at allowing the other side to learn about your claims and defenses, any witnesses that may be available, what facts are not disputed. You have the right to do the exact same thing. My question to you was whether or not you intended to do any written discovery, whether you intended to send him any requests for admissions of fact, whether you intended to send him any written interrogatories, whether you intended to send him any demands for production of documents.
I thought I did send it, but you saying that the other paper that he sent me, it
Yes,
just
ma'am.
looked like the same exact paper he sent the first time.
Okay, here's what I'm going to do. I'm going to give you guys another date. I'm going to continue your written discovery. The next date with me will be December 5 at 10 a.m. So let's get going on our discovery. Anything else we can accomplish today?
Well, on December 5, I hope we have a birthday cake because that's my birthday.
Well, happy birthday to you. Okay. Everybody will see December 5 at 10 o'clock. Your written discovery remains open. Thank
Thank
you
you,
for
Judge.
coming in. We are off the record.
Thank you.
Thank you.
Mr. Burke,
Hello, Your Honor. How are you doing today?
good, how are you?
Good, thank you. And I'm not driving.
I noticed, I'm surprised. Hello, what is your name?
Hello, you're talking to me, Tamara?
Yes,
Oh, my name is Tamara Ross.
we are on the record calling file number 22193775, Beaumont Health versus Tamara Ross, date and time for what appears to be our first pretrial. Could I have your appearances?
Yes, thank you, Your Honor. Hal Burke, P69068, attorney for Beaumont Health on this case.
Tell us your name again, ma'am.
Tamara Ross?
Is it your intention to represent yourself in this matter?
Yes.
You have an absolute constitutional right to do that. What you do not have is a right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind Mr. Burke will be binding on you. Do you understand that?
Yes.
All right. Where are we on this file, people?
Your Honor, as you stated, this is our first pretrial. Miss Ross and I have not spoken at all. If you'd consider allowing a quick breakout session, maybe we could resolve it right now.
Ms. Ross, because that's something you might be interested in?
Yes, please.
All right, let me put you guys into a breakout room right now then.
Thank
And come back to me one way or the other.
Will
Well, you know
do.
what might be better? How about I just do something a different way? And that way, if you are not successful, you don't have to come back.
Okay,
What I'm going to do is I'm going to give you both a new return date with me. Your return date will be December 5 at 10 o'clock. Does that work for everybody?
does for me, Your Honor.
Yeah.
Okay? December 5 at 10
Yes.
o'clock. We'll have another Zoom pretrial like today. I'm going to open written discovery at this time. Now, I'm going to put you guys into a chat room. If you are able to settle the case, come back to me. If not, then you can leave and go your separate ways, and we'll be together next December 5 at 10 o'clock, and your written discovery is now open. So let's get you into a breakout room. Room 3. Mr. Burke, room 3. Okay. We are back on the record, calling file 22-189-303. The file is entitled Michigan First Rehabilitation versus Progressive Michigan Insurance. We were last together on this file on October 10th, 2022. At that time, the parties advised the court that the amount in controversy now exceeded $30,000, which is obviously beyond the subject matter jurisdiction limit of this court. The parties were to agree to submit a stipulated order of transfer. It is now November 7th. No order of transfer having been submitted, the court will dismiss this matter without prejudice because I lack subject matter jurisdiction. We're off the record.
If you play bridge, you're doing more for yourself than getting out and having a brilliant card game every week. Turns out, playing bridge is a workout for your brain. They say that folks who play with bridge score higher on cognitive tests, and that playing bridge stimulates an area of the brain connected to your immune system. Well, now you're going to hear from another fellow who loved the game, CR539. CR539 used to be nothing certain for helpers who was living like a family with bridge. And if the other two players were late, Boomerang and Prokofiev would play piano together until the bridge partner showed up. Music by Francis Poulenc, a symphony, BBC Radio Orchestra, and I River Mountain. You're listening to a tempo of the music, including this hour. News is the world of power. Until then. The federal court has ruled Ontario Premier Ford does not have to appear at the inquiry into the federal government's use of the Emergencies Act. Or says Ford has the legal right to assert parliamentary privilege in refusing to testify. Ford in its former.
Morning.
Morning.
Morning. We are on the record 22-190-401. Priscilla Woodson versus Progressive Marathon Insurance. This is our second pretrial. Your appearances.
Yes, good morning, Your Honor. Connor Clardy, P84485, appearing on behalf of the plaintiff, Ms. Woodson.
Good morning, Your Honor. Carolina McGovern, P77064, appearing on behalf of defendant Progressive.
When we were last together on October the 10th, the defendant had not complied with the court's order concerning the 2.302A disclosures. Were those disclosures made?
Yes, they were.
Counsel?
Your Honor, I do not show a PIP claim file being provided by Sister Counsel's office. I do show that she did submit initial disclosures, but again, I'm not showing a PIP claim file. I'm showing a PIP pay log, but we would need the PIP claim file.
It was sent with the pay log. All the documents were sent in one email on October 13th. It's a password protected document, so perhaps the entirety of it wasn't saved.
Okay, take a look. Was it sent by you, Carolina?
No, it was not. It would have been sent by Danielle Williams in my office.
Okay, let me take a look. Okay, I do show a shared file folder from Daniel Williams. So I will, thank you for pointing that out, counsel. I'll go ahead and try to see if I can get that open. So yes, Judge, we're good.
All right. Now, what's the amount of your claim?
This is a relatively small PIP claim, Your Honor. It is for replacement services and medical benefits. There is a maybe somewhat of a minor dispute between sister counsel and I as to what that amount should be. I'm showing an outstanding PIP balance of $16,960. And the replacement services claim is not static. My client's actually still getting assistance around the house. So that claim potentially is growing. However, there is a dispute as to the medical. I'm not sure, maybe sister counsel can shed some light on that, but as of right now, I show it being $16,960.
That is inclusive of everything other than the increases of the household services?
Well, there is a Blue Cross Blue Shield lien that is floating out in the ether that we're trying to get
And that's how much?
we don't know that yet. I got a response from the Michigan Department of Health and Human Services saying that Blue Cross might be asserting a lien, so we're just exploring that.
But you don't have an idea how much that lien might be. The question that I have,
No.
obviously, is whether or not this case belongs in the district court or belongs in the circuit court.
Right, Your Honor. So I think at this time, it still does belong in the district court. And I think that's mainly because of this dispute as it pertains to the amount of the medical bills. It's not above $20,000 at this point. Or it's certainly not above 25,000.
At least without the size of the unknown lien you're unaware of.
Yes, that's correct, Your Honor.
Ms. McGovern, do you have any idea what the size of the Blue Cross Blue Shield lien is?
I do not. I don't believe that we've received anything from Blue Cross.
Okay, so the bottom line is we still don't know whether or not the case belongs here.
Right.
All right, let's get you another date and move on. I want to know the next time we're together, whether or not we're in the right place or not, Mr. Clardy.
Yes, Your Honor.
Your next date with me will be December 5 at 10 a.m. That work for everybody?
Yes, Your Honor.
Yes.
Okay, and what I'm going to do is I'm going to note question, subject matter, jurisdiction. So we'll have a hard number. At that point in time, where an idea, do you stay here or do you transfer? Anything else we can do today?
I don't think so.
I think we're good, Your Honor.
All right, December 5 at 10 o'clock. We'll try this again. Thanks for coming in. We're off the record.
Okay.
Thank you, Your Honor.
Thank you.
Carolina, I'm going to be sending you updated disability certificates. So you should get that soon.
Okay. Thank you.
All right, thank you.
Bye-bye. Just be safe out there.
You too.
You
Take
too.
care.
Thank you. Mr. Stratton,
Good morning, Your Honor.
Mr. Cohen.
Good morning, Your Honor.
Gentlemen, this is file 22-178276. Dearborn Total Automotive versus Olivia Martin. Appearances, please.
Good morning, Your Honor. Trevor Stratton, P65124 on behalf of the plaintiff.
Leslie Cohn for the plaintiff, or excuse me, I'm always a plaintiff for the defendant. I apologize.
Bar number.
I've only been a plaintiff lawyer for 40 years, but here we go. I'm so sorry.
The bar number, Mr. Cohen.
Oh, 34889.
Where are we on the file, gentlemen?
Your Honor, since the last time we met, I tried and failed again to get defendant 2 defaulted. So we haven't really progressed because of that. And I'm going to attempt, hopefully third time is the charm, to get that properly done.
All right, gentlemen, we're not ready to move on the file. I'm going to give you one more date, and then I think it's going to be time to refer you over to case evaluation. We can't get this thing done. Does December 5 work for both of you?
I'll go get my calendar, Your Honor.
Please.
It does work for me.
Okay, Mr. Stratton, let's see if it works for Mr. Collins.
December 5.
Yes, at 11 o'clock like today.
I have a motion for summary disposition in the morning. I can't imagine it unless the Macomb County Circuit Court doesn't hear it right away. If I can't see why I wouldn't be able to do it on the 5th.
Okay, December 5th.
But Your Honor, if I'm still in a hearing in Macomb County Circuit Court, I'll just have my can I have my secretary advise before 11?
Yeah, make sure you advise Mr. Stratton as well. That's not a physical appearance, is it?
I'm not sure. I just see in my calendar some motion for summary disposition in Macomb County Circuit Court. I think in Macomb County, it's optional. You could either be Zoom or live. I'll advise. If I can be there, if I can be present at 11, I will. If I can't, I'll advise.
December 5th at 11 o'clock. We'll continue your written discovery. Thank you, gentlemen.
Take care.
Have a good day.
Appreciate you coming in.
Thank you very much.
Be safe, Mr. Stratton. Okay, my second. Sizzler, I got. Let's try Michael Dials. Hello?
Hi, hello.
What is your name?
Robin Slappy.
Robin Slappy. Could you hold the phone? I think we should get started on your case. Robin Slappy, correct?
Yes, sir.
Okay, we can get started just a second. Get the other guy and we'll get started on your file.
Okay, sir, I'm sorry, I'm having a little bit of problem hearing you.
All right, you hear me now?
Yes, sir.
Counsel, your parent, this is case number 22-188-042, Gateway Financial Solutions versus Robin Slappy. Date and time for pretrial, your appearances.
Good morning, Your Honor. Zachary Schisler, P number 82247, appearing on behalf of the plaintiff.
And your name is, ma'am?
Robin Slappy appearing on behalf of the defendant.
All right, is your intention to represent yourself in this matter?
Well, not initially. Because of all the miscommunications and everything that had started with this whole thing, it was my initial hope to have representation as soon as we could figure out everything that was going on. So I received this notice Thursday evening before last to appear here today. So I have been trying to get representation, and I got an opportunity to finally get some callbacks on this past Friday. And because there's certain information that they needed me to upload, they were not going to be able to appear with me today.
All right, well, what we're gonna do is we're gonna get started on the file. And if you get counsel, have them file the appearance. The appearance is a document by which the attorney says he or she will represent you.
Wonderful.
You, of course, ma'am, you need to understand you have an absolute constitutional right to represent yourself. So if you don't get counsel, you certainly have a constitutional right to represent yourself. What you do not have is a right to your own set of rules, civil procedure, your own rules of evidence, and your own statutes. If you would like to represent yourself, as is your constitutional right, the same rules that bind counsel bind you. You understand that? Ma'am, do you understand that?
Yes, sir. Yes, Your Honor.
Then December 5 will be our next pretrial. It'll be on Zoom like today at 11 o'clock, and your written discovery is now open. Is there anything else we can do today?
No, sir.
Anything for you, counsel?
No, Your Honor.
Okay, I'm gonna send it to you, Ms. Slappy, because right now you're representing yourself. But if you get an attorney, make sure the attorney gets the notice of the pretrial, December 5 at 11 o'clock. Your written discovery is now open. Thank you both for coming in. We're off the record.
Thank you.
Thank you.
Let's be safe out there.
All right, you too.
Hello?
Hello?
What is your name? I can't hear you. What is your name?
hear.
Yeah, there you go. Tell me your name again.
Aretha Styles.
All right. Where's my other attorney? Okay,
Hello?
yes,
Yes. There you go.
okay,
Aretha Dowse.
all right, I'm waiting for the other attorney to join us here. Seems to be having a
I
problem.
don't hear you, sir.
Okay, well, just stay where you are. You're okay. Where are they? They're frozen on me. All right. I seem to have the other side freezing. So let me put you back in the waiting room. We'll try to meet you both again. Okay, the other side dropped out. They should be back shortly. Hello? Side dropped out. They should be back shortly. Oh, they seem to have appeared.
Hello, Your Honor.
Hello. Let's call the case. This is file 22-184-492. The file is entitled LVNV Funding versus Aretha George. This is our second pretrial. We were last together on this file on October 31st. And at that time, the defendant had not received the plaintiff's motion to file a first amended complaint. Let me have your appearances.
Oh, they still haven't sent it to me.
Appearances, please.
For the record, Your Honor, Eduardo Polaris, P63559 on behalf of plaintiff LVNV Funding.
And your name, ma'am?
Aretha Dowse.
You're the defendant in this case?
Yes. George is my maiden name.
I understand. Now, you say you don't have this motion,
No, they still haven't sent me the motion.
counsel?
Your Honor, our records show that we mailed it to the defendant over a month ago on October 3rd.
All right.
The last time we was here, the lady said that y'all didn't send me the motion. Y'all just sent me the paperwork for this court date. Like I never got anything to respond.
The court sent you the paperwork for the court date, ma'am.
Yes, that's the only thing I received. When we was here last week, the lady was supposed to send it to me in the mail for me to respond. I didn't receive it.
All right, this is what I'm going to do.
But
Ma'am, go
I
ahead.
am in the process of a bankruptcy. So do they want my bankruptcy information?
Have you filed for bankruptcy?
Yes,
When did you file for bankruptcy?
about 2 months ago.
We've received no bankruptcy notification, Your Honor.
Okay.
Your trustee is supposed to notify the attorney who's doing your bankruptcy. Does he or she know about this case?
Yes, well, I just found out about this case, so they was aware of it. Last week, I notified them that I'll be getting this case. I got this court date. You set this court date a week ago. I just received the paper on Saturday, so that's why I'm hearing nothing.
Your Honor, if I may, we scrub all public records in the bankruptcy system specifically to catch bankruptcies. We just scrubbed the system on November 4th, 3 days ago. There is no bankruptcy listed for the defendant.
I'm in bankruptcy with Ardeline, ARDELEANDUNNE PLLC. Do you need a phone number?
No. Have you filed it? I'm not asking if you're getting ready to file.
Yes, I filed it. They
All right, then
received the payment.
if you have filed the bankruptcy, ma'am, then you have a case number. What is the
Okay.
case number of your bankruptcy?
Okay, hold on. Let me get in. I guess I need to call my bankruptcy people because I just had to do a counseling credit counseling, fill out paperwork, send over my
No, ma'am, I'm
information.
not asking about that preparatory work, things that you have to do before you can file. I'm asking you whether or not a petition in bankruptcy has been filed in the United States Bankruptcy Court. If so, or signed a case number, and I want to know what that case number is.
I don't know a case number. They didn't
Right.
send me over a case number.
Okay, then this is what I'm going to do. I'm going to give you guys another date. I'm going to adjourn the matter to December 5th, 2022 at 11 o'clock. If a bankruptcy is filed by that time, the bankruptcy, of course, operates as a stay as to any state court actions. If not, I'm going to proceed with this motion to amend. There will be no further adjournments.
Your Honor, may I confirm the defendant's address so that we can fix the issue of her not receiving anything?
Okay, hang on for just a second. I'm going to put you guys in the chat room rather than do this on the internet.
Thank you, Your Honor.
Okay? December 5 at 11 o'clock. I'll put you in the breakout room now so you can get that information squared away.
Thank you. Have a good day, Your Honor.
You too. Be safe. Okay.